Kishan is a final year law student at Dr. Lohiya National Law University. He's a senior of mine, and obviously, before we started recording, we were mourning the tragedy that COVID 19, the pandemic, had done on any final year student across the disciplines. But in this episode, ladies and gentlemen, Kishan and I are going to talk about international arbitration and how this pandemic is going to transform the practice of international arbitration, because he has been working on a project which is very exciting, deals with international arbitration recently, and obviously he knows a lot about international arbitration. I've looked up to him, I've reached out to him for any help that I've needed with perhaps my mood, my papers, or anything of that sort. So I believe this episode is going to add a lot of value to anyone who's interested in international arbitration and knowing about how exactly COVID 19 is going to transform this entire practice. So stay tuned to the very end of this episode, because this is going to be a really, really fun chat. Hence, ladies and gentlemen, let's jump right in. All right, here we go. Welcome to the One Take Show, Kishan. I think this is a very, very special episode, especially for me, because I've had some very inspiring moments when I've interacted with you in the university, especially during my preparation for Justice R.K. Thanka Moot, when I obviously came up to you for advice with respect to certain issues that we were dealing with. You are considered to be one of the most prolific students with respect to arbitration, especially in our university as of this moment. So I'm going to make the best of this time that I have with you right now. So thank you so much for taking time off your very busy schedule. And I believe the schedule that we have today is Sunday. So thank you so much for taking time off your Sunday and sitting down with me for this conversation.
Thank you so much, Kaustubh. Thank you so much for having me here. In fact, I think I should be the one who should thank you, because you gave me this opportunity to, discuss my opinions on a subject which is very dear to me, arbitration law. I hope that we'll have a very wonderful discussion, and maybe we both of us get something really new out of this whole discussion for the law.
Well, it will be my honor to open this world to the genius of Kishan that we are going to observe right now here. But before we move ahead and we start talking about the very interesting topic that we have, that is the impact of COVID-19 on international arbitration and the various ancillary effects that it has and what all implications can follow. Before we can move on to that, a little bit of a background for all my listeners. Like, in law school, what inspired you, first of all, to take up law? Is there any specific story of yours? And apart from that, like, what inspired you to move towards arbitration? Is there a story there?
Yeah, there definitely is a story. So when I was in my school, I remember my father used to have a sort of legal battle with my uncle, and a lawyer used to visit my house. So I had a discussion with that lawyer, and he eventually led me to this new field which I was completely unaware about. And then I met a counselor. He advised me what all probabilities the field can offer, and like many others, I also came into the field. But arbitration law specifically, as an area of law, I chose to pursue in a bit more of detail because of my involvement in arbitration moots leisurely, and also interaction with famous practitioners like Gary Bond and in India, Mr. Sumit Peshwaha. So all these interactions and engagement opportunities that inspired me to pursue the law in a bit more depth.
Yeah. And do you have any future plans with respect to where in next like couple of years, where do you see you moving towards? I mean, obviously, I won't delve all the information out, because I think my listeners would really love to listen where you're coming up with from you yourself. So what is the plan for like 1 year from now?
Well, 1 year from now, I'll probably see myself working in a law firm only. Right. Probably, yeah. And after a couple of years, I plan to go abroad and complete my post-graduation from a university of a good repute in arbitration law.
Right.
But yeah, in short term, I don't really see doing myself brilliantly well in the field.
Well, I think that's a wonderful plan. But the really special part about that plan is that you are more than capable of actually fulfilling all those milestones that you have set for yourself. And this is something that I won't be bragging much about, because then I will spend the entire 25 minutes doing the same. So let's move to the interesting conversation that we are going to have today. COVID-19 as a pandemic has turn the entire world around on its head. We have some of the most devastating yet most interesting developments happening around us. One of the most radical changes that we have seen is in the international relations and all the dispute resolution setups that are happening between in this international diaspora that we have. Off the bat, before we delve into the details, what in your opinion is the impact, the general impact of COVID-19 on international arbitration as a field?
I think the pandemic is going to largely impact the way the field has been functioning for past, let's say, decade. Majorly, arbitrations in international sphere has been happening physically, wherein all the participants from different corners of the world come together, arbitrate at a particular seat, and then eventually an award comes, which is enforced in a particular territory. But now, because of the pandemic and because of the travel bans and lockdowns, none of these participants, made with the clients or the tribunal or the transcribers even, they're not even able to travel to a different country, or maybe not even in the same city where they reside. So I think that has impacted largely the way arbitration functions. No one is meeting now. So things are happening virtually. Everything has shifted to electronic mode. And that has brought like a huge wave of change in the modus operandi of the field itself, I believe.
And there's this one very specific impact on the stakeholders of this arbitration process. Like, what do you see is the direct impact on the stakeholders?
I think the biggest impact that the pandemic will be on the way arbitration clauses are drafted. Because if you see, mostly what practitioners do, and this is something which is like widely known throughout the industry, that arbitration clauses are mostly treated as midnight clauses, like they are drafted at the very fag end of transactions. But now what will happen is that people will reconsider their options of how they should draft the arbitration clause, because if they do not envisage virtual arbitrations or arbitrations happening remotely, then they might even not get a chance to represent their case, and hence the clause has to be drafted in a way that it addresses all these concerns and issues relating to what seat they should choose, because seat has a lot of relevance in arbitration law, because the whole supervisory jurisdiction of the court and the laws applicable in the state are also something which affect the arbitration. So people, the practitioners and the counsels which will be representing the parties, they will have to think what seat they are choosing, whether it like supports virtual hearings, because every jurisdiction has their own approach of how they go about hearings, right? So they'll have to reconsider which seat they are choosing, which institution they are choosing, because institutional rule may also not be competent or may also not be adequate enough to address all these concerns. So in fact, I think the way arbitration as a procedure is looked at by the practitioners and also the users, the clients, is going to be largely impacted. And it's just a matter of time to see how long this thing is going to stay in the field.
You talk about drafting the clauses. There has always been a problem with international arbitration that usually the clauses are are drafted in a half-assed manner. They are either copy-pasted from different agreements, not exactly suiting to the particular agreements. This problem has been persistent. Also, one of the issues that I came up to you with, which leads to pathological clauses or leads to disagreements over whether it's an ad hoc arbitration or it's an institutional arbitration and stuff like that. With pandemic, I think the inclusion of clauses like force majeure or the agreement to carry on the arbitration through virtual medium will actually somehow solve this problem. In your opinion, do you think that will this solve this problem? Advocates will pay more attention to the quality of arbitration clauses that are now being drafted?
Well, definitely, I think so, because if they do not do so, then their client stand a chance of losing their case, and that is not something which an advocate would ever want, right? So I think they'll be paying more attention to what all considerations they are giving or including in their arbitration clause, what arbitrators are selecting, whether he is equipped with all those technological know-how, the institutions, the seats, the procedural law governing arbitration. I think every other aspect related to an arbitration clause is going to be reconsidered. There is going to be a reconsideration of all these aspects, and we'll see how this this rolls out in the coming future.
Right, right. And with this, like, what else is there as an impact on the arbitration proceedings per se? When we talk about the fact that now it has shifted to the virtual medium, but what are the basic technicalities? I mean, would you like to delve a little bit deeper into the impact of arbitral proceedings on arbitral proceedings with this pandemic that is now shifting, let's say, cross-examinations, or let's say the evidence that are being submitted, or the stages of evidence, or multiple other such details that then fall under the proceeding part? What do you think is the impact on that? A little bit detailed analysis of the same.
Well, I think the proceedings which were already continuing, like the arbitrations which were invoked before the coming of the pandemic, for pre-COVID-19, they never expected anything of the sort that we are witnessing now. So they were all, like, the participants, the arbitration clauses, the institutions, they were all baffled. They had no clue what is happening and how to continue with the preceding arbitral proceedings. And what they eventually did was that all the scheduled scheduled hearings had to be cancelled. They had to be suspended, and that was the biggest impact on arbitral proceedings. They had to be completely suspended. And what happened eventually is that even the hearings which were scheduled in the future, they also had to be the procedural timetable, which we say, the terminology that we use in arbitration, procedural timetables of how the whole proceeding is going to go about in the future, that also had to be amended, because the clients and the counsels, they had no opportunity to consult each other. It's very difficult. I'm sure you and also the audience will understand how difficult it is to coordinate every aspect of an arbitration proceedings virtually. So because of meetings not happening, because of people not coming together to discuss the issue, the battle that they're going to fight before an arbitral tribunal, everything which was already in place, like a scheduled procedural timetable and everything, they had to be amended. And some of the institutions like SISC, LCIA, ICC, they have started providing virtual platforms to the suspended arbitral hearings so that they can continue seamlessly. But most of the proceedings which were continuing, they had to be suspended. So I think that has been a major impact that the pandemic has had on the arbitral proceedings.
Right. And about those practical aspects which are involved, for example, when we say, let's say, for example, as I mentioned before, the submission of the evidences or the various stages of the evidences and cross-examination, it obviously plays a huge role, especially in arbitration, at least what I know from the domestic arbitration. When it comes to international arbitration, do these processes or these part of the arbitration process also gets affected? And if it is getting affected, how is the virtual new method of arbitration proceedings going to somehow tackle the problem of no face-to-face cross-examination or the various developments in that sphere?
I think if we look at the considerations, the concerns arising out of virtual hearings, then we can divide the concerns in two parts. One can be the concerns which are practical in nature, which have nothing to do with the legal side of it, and the other is obviously the legal concerns arising out of virtual arbitration. In practical considerations, what we have to look at is the coordination between parties coming from different time zones. As I said, some of the parties may come from New York, the other may come from Japan or South Africa or from Mumbai or New Delhi. So it may be very difficult to coordinate between all of them, the time zones, because one of the parties might be going to sleep at the time when the hearing was scheduled. And in that case, you can contemplate how this thing is going to be related to legal concern also, because then in that case, the party will not have the feasibility, the suitability of presenting his case in the most appropriate manner possible, because he'll have to wake up late at night, at midnight, let's say, and argue his case, which is like a very something which no one would expect himself to do. So in that case, it can squarely fall under one of the grounds which is enumerated under the New York Convention, Article 5(1)(b), which talks about due process concerns that the party was not given a proper chance of hearing or a
Mm-hmm.
proper chance of presenting his case. So practical considerations like this can eventually lead to legal concerns which can be raised at the time of enforcement or at the time of setting aside an arbitral award.
Mm-hmm.
That is what we need to look into. Other practical concerns can also relate to selecting the platforms. So, for
Mm-hmm.
instance, let's say you and me are arbitrating, and you know that you have a very weak case, and you are most susceptible to to losing this case. You're the most vulnerable party,
Mm-hmm.
and in that case you'll always act in a recalcitrant behavior,
Yeah.
and that behavior can always ignite you to, I mean, it can always entice you to not come at consensus with the other party, isn't it?
Yeah.
So for example, let's say because of virtual hearing we have to select a proper platform, may it be WebEx or Zoom or let's say
Mm-hmm.
Microsoft Teams. Now, all the participants, the tribunal, both the parties, and everyone else has to come to a consensus as to which platform are they going to use,
Yeah.
because there are sundry platforms available in the market, and in
Mm-hmm.
fact, the international law firms, they have their own set of platforms that they prefer using in international arbitration. So there can be, sort of confusion regarding that.
Yeah.
And in that, it's a very relevant concern. I tell you why. Because you see, in Microsoft Teams, there are some features which are not available, like
Mm-hmm.
breakout rooms, which is like a very required,
Mm-hmm.
required sort of procedure in arbitration. You need to discuss certain things personally with your client, and for that, you need a breakout room. And this feature is not available on Microsoft Teams. So you might want
Mm-hmm.
to, discuss it out and come, let's say, argue it out with your other party to change the platform. So things like that can affect, and like these things are the ones which will come into the practical concerns of organizing an arbitration virtually.
Mm-hmm.
Speaking of the legal concerns, the biggest concern is something that I've told already: due process concerns, because not all the parties are capable or have access to technology. So all
Mm-hmm.
these issues may eventually lead to them not being able to present their case,
Yeah.
which can very well be challenged under Article 5.1b of New York
Mm-hmm.
Convention, or also Article 5.1d, because
Mm-hmm.
5.1d article of New York Convention, it says that parties can challenge an arbitral award if the procedure was not in accordance with the agreement of the parties.
Mm-hmm.
Now, if parties had not envisioned anything in their arbitration clause, and when they had discussion
Mm-hmm.
on virtual hearings after the pandemic, they
Yeah.
one of the parties said, "See, this is not what I'm comfortable going forward with."
Mm-hmm.
So, on that particular ground, he may raise challenge at this stage of enforcement and say, "See, this is not what I agreed to, or this is not the procedure which both of us agreed to, and hence this award is amenable to be challenged
Mm-hmm.
and should be set aside." So things like these, concerns like these, are very relevant when it comes to legal concerns. Other legal concerns can relate to the concerns of confidentiality and
Yeah.
data protection.
Mm-hmm.
Right. So if you see the recent, in fact, the Indian Arbitration Act was recently amended in 2019, which
Mm-hmm.
added Section 42A to
Mm-hmm.
the Act, which talks about confidentiality of the proceeding, and that all the participants have to make sure that the proceedings are confidential in nature. Now, you can I mean, this is something which a layman can also construe out of the situation. You can have a virtual hearing on your laptop, on your personal laptop, or maybe let's say you can after the proceedings are over, you share your laptop with your relatives or your family members. So
Yeah.
there's a likelihood of the data or the proceedings,
Mm-hmm.
everything related to the proceeding, getting leaked to a third party, because from the context of that proceeding, those are the third parties.
Mm-hmm.
So there's a concern that issues like confidentiality and data protection also can be breached because of virtual arbitration. And
Right.
like international efforts have been made, protocols have been devised by various arbitral bodies, but it is
Mm-hmm.
like it's something which we can only see in the future how it rolls out.
I think that makes a lot of sense. One thing that you mentioned, and I think I should clarify this before we move forward, is the fact that now, since there are countries that are now, for example, in different time zones, and they have to collaborate with this entire change, would this also have some impact on the sort of relationship between seat law, proper law, and the applicable law that is on the arbitration agreements? Would the seat law or the jurisprudence behind the same, since we've seen so much development regarding seat law recently in India, will this be affected with the COVID-19 really impacting this entire international arbitration procedure?
No, I think I understand where you're coming from. I mean, I
Mm-hmm.
completely see this concern as a legitimate one because you see, when we say the jurisprudence revolving around state law, we essentially concern ourselves with the determination of state, isn't it?
Mm-hmm.
Like whether the seat, the place designated, was it meant to be seat or was it just a venue, things
Mm-hmm.
like that. And I think this is something which is going to be at the forefront because now, if arbitral proceedings are going to be happening virtually from
Yeah.
people located at different corners of the world,
Mm-hmm.
then the relevance of seat law is going to go is only going to increase. It's not going to decrease because
Yeah.
now even if the arbitration is happening virtually and everyone is sitting at their homes and conducting the proceedings, but
Mm-hmm.
eventually everything will boil down to the fact that what the state law does, what the state law prescribes, whether it allows arbitration proceedings to be conducted in such a manner, or whether what all concerns the parties may have with respect to state law. So I think the importance is only going to increase. Earlier, parties used to go to the seat, but now when they are
Mm-hmm.
organizing the whole conduct of the proceedings from their place of residence, so probably the significance of seat is something which is going to be of great relevance to the participants.
Right, right. I think with this we come to my last question. I think one of the most important questions. With all these developments happening around the world, what difference or what changes do you prospectively see in India, as in how and what will possibly change in Indian scene with respect to Indian arbitration? What strategies can be adopted, or what strategies will be helpful? Anything of that sort. What prospective changes do you observe happening around India?
Well, in fact, after referring to multiple literature relating to this particular topic, I refer to the Indian Act to see whether the Act is adept to respond to this uncertain time. And I
Mm-hmm.
found two very interesting provisions under the Indian Act. One is Section 7, and the other is Section 19, subclause 3 of the
Yeah.
Act. Uh, Now, Section 7 is not that relevant, but Section 19 is very relevant. Section
Mm-hmm.
19 talks about the rules of procedure. It says that the parties are free to agree on the rules of procedure. And
Yeah.
let me just clarify it on the very outset that Section 19 empowers parties to choose institutional rules of procedure.
Mm-hmm.
And it is something comparable to Article 19 of the UN Civil Model Law of 1985.
Right.
So Section 19, if like parties are going for institutional arbitration because of Section 19, they can also opt for virtual hearings
Mm-hmm.
and virtual arbitral facilities provided by various institutions. For example, HKIC, the Hong Kong International Arbitration Center, and ICSID, the Investment Dispute Center located in
Mm-hmm.
Washington, they have started providing various virtual hearing facilities. So probably parties may want to use this provision to opt for their hearing facility, and because it gives them the power to. Now, what is even more interesting than this particular development is the fact that clause 3 of this section says that the arbitrator has power to determine the rules of procedure if the parties fail to do.
Mm-hmm.
Now, if we're talking in Indian context, where we know that most of the arbitrations are happening on an ad hoc basis and not on an institutional basis,
Right.
most of the arbitrations do not envisage a particular institution's arbitral, rules. So it is very difficult to see what parties had agreed to, and that is where the role of the arbitral tribunal becomes quintessential, because the tribunal will then be, let's say, the competent authority to take decision on whether to go ahead with virtual hearings or not. So I think if in the Indian seated arbitration tribunals, especially the ad hoc ones, which are more or less, possible, more or less happening in India, if Indian seated arbitral tribunals want to go for virtual hearings, they, I think, are going to rely on clause 3 of section 19, and that is exactly where they're going to take that power from. The other section that I mentioned, section 7, it just talks about use of electronic form to sign arbitration agreement. So I can envision in the future when parties want to enter into, sort of agreements, they'll probably rely on electronic mode of agreement signing and everything. But definitely, I think the Indian Act needs to be amended because Section 24, which talks about hearing, does not envisage virtual hearings in the scope of what qualifies as hearing, and that is an issue which needs to be resolved because every participant, every international at least user of the arbitration is looking for those rules and those arbitration procedures which allow virtual hearing. And this can be seen in the United Arab Emirates arbitration law. They recently amended their Arbitration Act in 2018, and their Article 28 explicitly allows virtual hearings. And similarly, LCIA is the London Court of International Arbitration. Its 2014 arbitration rules, it also allows virtual arbitral hearings explicitly. Now, I think except for these two instances, there are hardly any other institutional rule or domestic legislation which talks about conducting arbitral hearing, mind you. And this is something which is different from video conferencing. Video conferencing can very well happen through virtual, and most of the institutions will provide for the same. But conducting the whole arbitral hearing, wherein you argue the merit phase also through virtual mode, that is very rare to see. And I think to that extent, the Indian Act also needs to be amended. The definition of hearing needs to be broadened, and how hearing can take place under Section 24, as I said, needs to be reconsidered by the legislators.
Wow, that's, I think, the fact that there are so many areas that are yet to be explored, the fact that we have such an opportunity right now to somehow understand, analyze all those changes that are happening around us with the present context that Indian arbitration scene provides us with, the changes that can happen, so beautifully explained by you to all my listeners who will be really be, I think they will cherish every moment of this conversation, will really take a lot of benefit out of this, will understand the idea of how exactly international arbitration through various methods, through various institutions, through various countries, other just in India, but also the impact that it is having on India, will create the change that we are about to see. Well, I believe this is one of the most interesting conversations, one of the most constructive conversations around arbitration that I've had. Thank you so much, Kishan. I've had a wonderful time talking to you. Do you have any closing remarks for our listeners?
Well, there was one thing which I wanted to point out, but I think because of the time constraints, I didn't point out. And if you may allow me, I wanted your viewers to give an attention to that as well. If you see the recent, the 2019 Amendment Act, which was passed in India, it talks about institutional arbitration. And I think this is something which everyone has given an eye to, but it does not talk about virtual hearings at all. Now, if you see the arbitration rules of institutions in India, like MCIA, I even went through the rules of MCIA, Mumbai International Arbitration Center. It allows video conferencing for witness cross-examination and communication through electronic means. Now, obviously, ad hoc tribunals are not going to give you these facilities, virtual hearing facilities. So this pandemic is really going to give the institutions which are in the pipeline of coming in India a really good impetus to develop and become and making India an institutional hub of arbitration. So I think the intention of the Act, the Amendment Act 2019, is going to be fulfilled because of this pandemic, even though not in the way the community would have wanted, but definitely in a positive manner, I think.
Well, I believe that is That's a very sound understanding. I think the institutional arbitrations have now become a rather interesting conversation that we keep happening about all the developments that are happening in Delhi, how India is being looked at the arbitration hub, and how we are going to develop as a country. We are investing a lot of energy and a lot of resources into developing India as a very potent arbitration hub, especially in Asian and as against Southeast Asian countries. So I think yes, the idea that you propound here is extremely useful, and with all of this keeping in mind these developments that you've discussed, I think a lot of our listeners would like to reach out to you at some point of time. How can they reach out to you, and how can they discuss all of these things?
I'm sure they can find me on LinkedIn. I'm always
Mhm.
active on LinkedIn. So if they want to do something, I'm very happy to have a conversation with them.
Absolutely. And just for all my listeners, I'm going to warn you this: Kishan's LinkedIn is something that will give you the kind of identity complex that you do not need during the lockdown. But please do visit his LinkedIn at your own cost. He is always available. Thank you so much, Kishan. I had a wonderful time talking to you. I hope you had a good time too.
Thank you so much, Kaustubh. It was a pleasure having a discussion with you.
Thank you. Thank you so much, Kishan.